Hello everyone. On behalf of ANROS, I would like to welcome you to today's webinar, Safety in the Family Court. My name is Michelle Robinson and I'm the Director Evidence to Action at ANROS. We are excited to once again be joining you from a studio where we are lucky enough to be able to gather together to talk about today's important topic. I acknowledge the traditional owners of the land on which we are meeting, the Gadigal people of the Eora Nation, as well as the traditional owners across the lands from where you may be joining us. On behalf of ANROS, I pay respect to elders past, present and emerging. Wherever we are today, we are on unceded Aboriginal and Torres Strait Islander land, and I acknowledge and pay respects to Aboriginal and Torres Strait Islander people who are participating in this webinar today. Today's webinar is a panel discussion followed by the live Q&A, our normal format. This is a confronting topic, so please take care of yourself during the webinar. If you would like to access support, you can contact 1800-RESPECT on 1800-737-732 or Lifeline on 131114. The webinar will be recorded and will be available on the ANROS Notepad as soon as possible. You can subscribe to Notepad if you haven't already to be notified of when it will become available. Finally, we have a survey that will pop up as you exit the webinar. If you could take a couple of minutes to complete it, your answers are really helpful in improving our webinars going forward. So how do we keep women and children safe in the family court? This question has prompted many new initiatives in the family court and the Federal Circuit Court. Going forward, we'll refer to them as the courts, particularly over the course of the last year, as the courts have agilely responded to COVID-19. This question of improving safety is also occurring within a context of great change, stemming from the impending merger of the courts to create the Federal Circuit and Family Court of Australia, the interim reports from the Joint Select Committee on Australia's Family Law System, and the review of the ban on direct cross-examination, submissions for which close at the end of this week. Today's discussion will focus on what is needed to keep women and children experiencing violence safe within the courts. I'd like to introduce you to the panel. Janet Carmichael, the Executive Director, Child Dispute Services within the courts. Dr. Jane Wangman from the University of Technology in Sydney, who is the lead researcher on the report we'll be discussing today. Associate Professor Molly Dragowitz from Griffith University in Queensland, who is also on a research team, the report of which we'll also be discussing today. Tracy Turner from Bundjalung Country. Tracy is a domestic and family violence specialist worker with an Aboriginal focus at the Sydney Women's Domestic Violence Court Advisory Service, or Advocacy Service rather, otherwise known as WDV-CAS. Angela Lynch, CEO of Women's Legal Service, and Dr. Ray Kaspiev, the Executive Manager, Family Law, Family Violence and Elder Abuse at the Australian Institute of Family Studies. Welcome everybody, and thanks for joining us today. Okay, Janet, to begin with, could you outline for us what has been happening in the courts in relation to improving safety?
Thanks, Michelle. Great question. And before I respond, I too would just like to acknowledge the Gadigal people on whose land the Eora Nation that the panel meets today always was, is and will be Aboriginal land. I also want to start by saying the court has always had a focus on safety, and there's been a raft of long-term initiatives at play in the court for many, many years, including a family violence plan, a very active family violence committee, family violence best practice principles, and there's been regular training on family violence. So I think it's important to acknowledge that we're not starting from a zero place, but there's no doubt it is a really exciting time in the court at the moment. There's so much happening. There are many recent initiatives and pending reforms that I think are going to really go a long way to addressing the needs of court users. And look, I'm going to list and go through a number of those reforms today. I can't cover everything, but there's detail about most of these things on the court's website. But I think it's important to explain that the overarching objective of all these reforms is to ensure the protection of children and vulnerable vulnerable people. We're also keen to minimise any mechanisms for the perpetration of systems abuse. And we also believe families should have some agency and decisions made about them to the extent that's appropriate. We're conscious of the siloing of systems, so the reforms are designed to minimise that the sort of information gaps that happen because of those systems. And also we're aware that it's very important that people move through the court efficiently and effectively. So they're the sort of overarching objectives of all the reforms and initiatives at play at present. So just to run through some of those, for some time we've had a specialised list called the Indigenous list. It originated in Sydney, but it's been expanded and is now running in a number of locations. And that's a really important initiative to ensure the court meets the unique needs of Australia's First Nations people. And it is certainly where the lists are run, they are heavily supported by local Indigenous organisations. And my colleague here on the panel is actively involved in the Sydney list. So that's a really important ongoing initiative, and excitingly the court's just received some additional funding to engage 4 more Indigenous liaison officers to support those lists. We also have the ban on cross-examination that came into effect in 2019, where legal aid is now funded to provide representation so that victims don't have to cross-examine or be cross-examined by perpetrators, which was a great initiative. Late last year, the court introduced a new notice of risk. So this is a compulsory form that all parties must now complete, and they're required to provide a raft of information across all of the risk domains. And that's a really important set of data to inform the court in terms of how it manages cases. It also gives us a really good picture of the client user group. Information sharing, as I said before, the siloing of systems that we're all aware of, that's a historic problem. But unfortunately, as we know, many of the families that each of the systems are involved in multiple systems at the same time, and yet we don't have effective mechanisms, or we haven't had effective mechanisms for sharing information. So the government has funded the police and child protection agencies to place a worker in the family law registries, and that's seen a great difference in the court's access to early and important information that's held by those other systems. And again, very pleasingly, the whole information sharing framework received a big funding boost in the recent budget announcement. There's what we call the PPP 500, which is an initiative that came about under the Women's Economic Security Package, whereby for matters with a relatively small property pool, under 500,000, the cases are expedited through a case management process offering ADR in and endeavouring to try and maintain as much of the parties' assets as possible. And I think that's been a great initiative. It's a formal pilot in 4 locations, which will be reviewed. So that's, I think, addressed some concerns that came out of a report called Small Claims, Big Battles, about how women were financially disadvantaged by the court process. There's obviously, as all agencies, we had to get really creative last year, and there was a rapid increase in the use of video, which saw the court able to maintain a 90% clearance rate, which was really important because access to justice had to continue through COVID. But we've learnt a lot, and while many of the court events will revert now to being in person, we've now got the capacity and the skill and to use video a lot more than we have in the past to ensure people are kept safe and people have access. The COVID list came about through some communication between the courts and people in the DV sector, notably Angela here on the panel, to deal quickly with issues, the conflicts that are arising directly out of COVID. And pleasingly, that's been expanded and has been further funded and will run now through till the middle of 2022. And that sees matters triaged very quickly and put through to a first hearing within 4 to 6 weeks. Family violence training, as we all know, is key, and you can't just do it once. You've got to keep doing it because it's an emerging field. And so we have had family violence training over the years, but we've had a real concentrated effort of late, and there's a very expansive and comprehensive internal program that's completed by family consultants and registrars, associates and the like. And we are about to embark on some further training with the Safe and Together Institute, which I might speak a bit to more later. Also, judges have training through the National Judicial College of Australia. ADR is not something people think about in regards to pairing matters in the court, because for many years the court hasn't been offering that, but we're now reintroducing ADR for those matters that it's appropriate to do so. Obviously not for every matter, but we believe people need to have another opportunity to have more agency over their family and the outcome. So it's a very different type of ADR to what's offered in the community sector. So it's done within a court context, and with that, there comes a certain authority, and it's facilitated by registrars, often in conjunction with a family consultant, so a social scientist who's focused on the needs of the children. Legal reps are present if people have them, and we also have ICLs engaged in that process. So it's quite a different ADR. The outcomes to date have been really pleasing, and we're going to see that expanded quite significantly going forward. And as you mentioned before, there's some structural reforms on the way, and those will be helpful to support many of the reforms that the court already had in train. So they'll see things like a single point of entry into the court, a harmonisation of the rules between the systems, a new case management process, which will see greater use of registrars and ADR, as I said, earlier identification of risk, and then repeated risk screening along the way. And we'll also have some new assessment process for moving matters between the two divisions so they can't bounce around. So, look, it's all really exciting, I have to say. And I just want to quickly say the last budget saw the single largest injection of funds into the family court, which is really exciting. We have a lot of new positions we're now needing to fill. Really exciting time. We're recruiting family consultants, registrars, administrative staff, support staff. So it is a really exciting time, and I encourage anybody who might be eligible to have a look, because I think there's a lot of rewards now coming into the court system.
Thanks, Janet. That is not only a comprehensive list, but really responsive in terms of the changing setting that we're all finding ourselves in. Appreciate that. So, Jane, you've recently completed a research project which actually explores the impact and effect of self-representation by one or both parties in family law proceedings where there are allegations of family violence. Can you tell us about the ways in which self-representation can affect safety, and then the impact in turn on the proceedings or the presentation of a case?
Thanks, Michelle. So this research project, which I recently completed with Tracy Booth and Miranda Kay, both from UTS as well, as Michelle has said, explored the impact of self-representation in family law proceedings involving allegations of family violence. It was a very large study, so we did a lot of field work. We interviewed people who had represented themselves. We interviewed key professionals, so judges, lawyers and other support workers. We observed court proceedings in metropolitan and regional courts, and we also had a look at court files. And we were interested in the experience of victims who were representing themselves, facing a perpetrator who was representing themselves. And of course, for some people, their matters had both of these things, both parties were self-represented. Being a victim of family violence added a complex layer not only to the self-representation but also to questions of safety. So the experience of family violence, which was often continuing whilst the litigation was on foot, meant that it not only framed and shaped the issues that the case concerned, but was also the environment of the litigation of which people were trying to do their best to conduct their self-representation. How safety was experienced or addressed for self-represented litigants varied enormously depending on what court they went to, the judge who presided, whether there were lawyers involved, whether there were other support services available at the court. So in the brief time I have today, I'm going to try to talk about three dimensions of safety that emerged in our study. The first one is safety at court. The second is experiences of processes as being abusive. And finally, looking at whether the outcomes achieved address safety concerns, particularly in relation to parenting matters. I must say at the outset that many of these are shared with victims of family violence more generally. However, the absence of a skilled lawyer meant that the safety concerns or issues were heightened for self-represented litigants. They took some time to be addressed or may not have been addressed at all. So in terms of safety at court, a number of the women we interviewed reported abuse taking place at court. And so this included things like being followed to and from the court, verbal abuse, being yelled at in the court building, being cornered in very small spaces like lifts, the perpetrator walking past them all the time, walking past the safe room. And while these are common experiences for all victims of family violence, what made it different for self-represented litigants was that they often didn't know what services the court had available that could assist them. So they didn't know about safe rooms, and they didn't know that they could ask security or do a safety plan. So lawyers perform this important function of telling them about what's available and linking them into those services. So self-represented litigants often didn't know about these things until they attended court on the first occasion, and even then it depended on whether there were services available to help them. Lawyers also perform a really important function of being a buffer between a victim and a perpetrator, and this is very clear and marked when both parties are self-represented. It's having that absence of anyone trying to act as a buffer between the two parties. One of the other things that emerged in our study was that not all safety measures are available at all courts. So we went to both metropolitan and regional courts, just a small number of them, and we noticed a really distinct difference for the regional courts that we visited. So the Federal Circuit Court of Australia does a circuit of regional courts where they go like 4 times a year. And in those locations, the Federal Circuit Court uses a state court building. And we found that at the 2 regional courts we visited, there was no safe room, there were few interview rooms, and generally one overcrowded waiting area. So one regional court we visited had 70 matters listed on a single day, 1 entrance, 1 lift, 1 stair, and 1 large common waiting area. For a couple of the women that we interviewed at this regional court, they talked about the difference. So when they went to the state court building to get their protection order, they had a support worker and they had a safe room. In exactly the same building, but just in a slightly different area, there was no safe room and there was no support worker, but it was the same alleged perpetrator. Abuse was also experienced inside the courtroom. So women told us that and we observed it as well, that there was yelling in the courtroom, verbal abuse, being stared at, having perpetrators bang on the bar table and so on. Again, it was variable in terms of whether or not their behaviour was controlled. So Jenny, one of the women we interviewed, had a really good experience from her judge who pulled up her former partner saying, and I'm going to quote what Jenny said, the judge said, "I will not allow you to commit domestic violence in front of me. I can see what you're doing. Don't look at her." However, we also had reports about judges not addressing the behaviour, just letting the ranting and yelling continue without any comment or restriction. During court proceedings, people can call on a range of measures like audio-visual link and screens in order to assist them in giving evidence. But we found that self-represented litigants didn't necessarily know that they could ask for these things. And indeed, one of the women we interviewed didn't know about them until we asked her questions in the interview. In terms of processes, I'm not going to talk that much about it, but I just wanted to say that women reported to us that they experienced parts of family law processes as a continuation of the abuse. And so that might have been because the alleged perpetrator chose to self-represent and use that as an opportunity to continue to harass them. One of the things I think was notable from our research was that it started from the outset. So a number of the women we interviewed started out paying a lawyer, only to face what appeared to be quite a deliberate strategy to deplete the funds that they had available. So basically a form of financial abuse. So the woman's lawyer at that time would be bombarded with correspondence, multiple applications, adjourned court dates and so on, that the lawyer had to respond to, which finally left the woman unable to pay for any representation. In terms of outcomes achieved, many of the people we interviewed weren't happy with the outcomes that they achieved, and that's perhaps unsurprising. What they were pointing to was they were unhappy with them because they didn't ensure safety in terms of their parenting orders, or they accepted less than they were entitled to in property matters in order to placate the perpetrator. It's important, I think, to note that for some of these women, these orders were achieved when they had a lawyer. And so it was their dissatisfaction with that unsafe order that led them to be self-represented. And so I think we need to be clear that what we're talking about is competent and skilled lawyering in this area, and that certainly some of the women we were talking to, again, reported things that we know from other studies about lawyers minimising or promoting contact rather than safety and so on. Whether a parenting order addresses safety has a number of interrelated aspects to it that I think are really brought to the fore when you have a self-represented litigant. So one of it is whether or not self-represented litigants are aware of the types of orders that they can ask for that might enhance safety. One of the things that Janet mentioned is also about how well family violence is documented and evidenced in the paperwork. And this was a clear gap. So here we're talking about notice of risks, affidavits and subpoenas. Self-represented litigants didn't tend to issue any subpoenas at all. And yet here, it's these documents, particularly the affidavit, that present your evidence. So one of the judges that we interviewed said, you know, if you prepare your affidavit in a way that's the evidence is admissible and compelling, then it's going to be given weight. And the judge went on to comment that self-represented litigants don't do this well. I guess it's also important to note that a lot of the judges also said that lots of lawyers don't do this well either, and that there is this real clear need to increase competent lawyering. The paperwork has this flow-on effect. So if the paperwork's inadequate, then you're not in a very good position to negotiate. It frames the consent orders that might be being formulated, and it frames the hearing. So it just sort of has this flow-on effect. So one of our key recommendations was to do something about assisting self-represented litigants with the preparation of their documentation. In terms of negotiation, so most family law matters are resolved by consent. And the women we interviewed experienced considerable pressure to agree to consent orders. So they talked about pressure from the judge, the lawyers on the other side, often describing those lawyers as being bullying and so on. They also experienced pressure and threats from the perpetrator in terms of consenting to orders. I guess one of the things I'd like to emphasise is a lot of this negotiation takes place at court, outside the courtroom. And whilst we've done a lot of work around mediation and alternative dispute resolution, around imbalances of power and so on, this negotiation of court has been left largely unattended, and we need to do something about that. I'm conscious of the time, and I think to finish off, I'd just also like to point to the fact that the continuation of litigation is also something where safety comes up. So for some women, they continue, so even when they got final orders, whether by consent or after hearing, they were involved in continuing litigation. So sometimes this was their own litigation, where they kept going back to court to vary orders or do contravention proceedings or appeals in order to enhance the safety that they didn't get the first time around. For other women, they were dragged back to court for contraventions and so on, so they were experiencing the process as abusive. In our report, we point to a number of measures that could make a difference. So expansion of the Family Advocacy Support Service, the FAS, more resources to the court, so it's really good to hear about the budget. Assistance with legal documentation, funding legal services for those people that continue to litigate, so not just the duty lawyer service model, having a more centralised source of information, and of course finally training and education for key professionals around family violence, particularly lawyers, which seem to be a gap.
Great, thanks. Jane, that's been really timely research, but also really critical research, and I think this is a critical conversation in terms of having here today court representatives from the court and practitioners around the table. So thank you for drawing some of those findings out. And Molly, you've been part of a research project with Anne Rose also looking at complex trauma and implication for women's safety and well-being. What did you find in the ways in which trauma and safety intersect and how this plays out in the court?
Well, our complex trauma study didn't set out to investigate survivors' experiences in the family court, but it turned out that the whole family law system, not just the family court, ended up being a really key site for trauma for our complex trauma survivors. And the distinction between just normal trauma and complex trauma is the repetitive, ongoing nature. So you can really see how that fits in with the dynamics of domestic violence. So a lot of the survivors in our study noted that their abusers were using the family law systems and family court to engage in what Jane has alluded to, this systems abuse, using the systems to deplete financial resources or just win the divorce against their partner that they had been abusing before separation. So for the survivors that we spoke to for our study, they experienced a few aspects of the family law process as particularly traumatic. So the things that were invoking trauma for them were basically all related to this fact that the family law system kept them from effectively being able to separate from their abuser. So if the abuser wanted to maintain contact with the children, you have domestic violence survivors that are now stuck in an abusive relationship with this abuser until their children are all effectively adults. And even in those few cases where the partner that was reported for domestic violence does not have physical overnight parenting time with the children, they're most likely going to end up with equal shared parental responsibility, which means that domestic violence survivors are forced to negotiate over key areas of parenting like education, healthcare, and counseling. And what happens then is sometimes the abusers can prevent the children from receiving counseling to sort of deal with the trauma that they're experiencing from being part of domestic violence, because we know now that children are central to the dynamics of coercive and controlling domestic violence. They're not just witnesses that overhear something occasionally. So the survivors in our study were particularly traumatized by the fact that they had no control or way of telling how the family law system would play out, so the unpredictability. And Jane's alluded to how it can really depend on the judge you have, the lawyer that you have, the court that you're in, what resources you have, and what experiences you'll have as a result of that. The survivors in our study were also really traumatized by the way that the domestic violence was minimized and dismissed. And so even when they managed to get domestic violence as part of the record that was being discussed in court, it tended to be dismissed as something that had happened in the past, and that they should be forward-looking and not be rooted in the past, and should be willing to work together with their abuser in the best interest of their child. So the survivors found this really traumatizing. And then the other thing that was really traumatizing for our survivors was the fact that they weren't able to protect their children. And this is particularly ironic, I guess, because many of the survivors actually went on to pursue the separation and divorce from the father of their children when they realized they couldn't really protect their children from the violence. So they enter into a system seeking help to achieve this separation, and then they find they're now stuck in an ongoing abusive relationship that's enforced with the backing of the state. So those are the main findings from our survivors in our study.
Thanks, Molly. Tracy, I'm going to segue directly to you because you work at the Sydney Women's Domestic Violence Court Advisory Service with Aboriginal women, and safety for women and their children in the family court, as we've heard, is not just about trauma-informed, but it's also about cultural safety. Can you tell us more about what that means for you and your clients?
Yeah, of course.
And your work?
First, I'd like to acknowledge the Gadigal people of the Eora Nation, traditional custodians of the land of what we meet today. I pay my respects to their elders, past and present, and I extend that respect to Aboriginal and Torres Strait Islander people here today. So cultural safety for Aboriginal women is vital in our court system. Aboriginal women need to feel heard, respected and listened to. While there's a great amount of progress in this area, we still have a long way to go. There's much more stability in the programs and support for Aboriginal women and their families in the court system. Family is extremely important to Aboriginal women. Going past the nuclear family and into kinship relationships. This also connects to our communities. It's been long misunderstood by the court system, while the family court is attempting to mitigate this, understanding and bringing in the Indigenous List Day. From the beginning of the court process, Aboriginal women and their families already feel threatened to walking in the courtroom for many reasons we already know about. This includes colonisation, intergeneration trauma, and the ongoing fight for Indigenous families to feel heard and also for their children. On top of this, Aboriginal women have a real fear of losing their children, and this all comes down to the stolen generation. The family court demands a very specific and formal language that is entirely foreign to Aboriginal women. Aboriginal women are strong and we know what we need, but it's important to allow us to speak freely so we can lead in the court and we know what's best for our children and for our families. This reduces the appearance of Aboriginal women coming across as spiteful when we're just frustrated. It also takes into account our culture, traditions, or kinship relationships, and the child-rearing practices of Aboriginal and Torres Strait Islander families. Currently, in the way the family court runs Indigenous lists, allows Aboriginal families to be heard in a respectful way. It keeps our women safe and it has our matters heard in closed court. The judge, family, legal representation sit together on the bar table, much like a yarning circle. This removes the physical hierarchy of the judge proceeding from a bench that enforces the hierarchical that the Aboriginal women are often faced with, reduces the intimidation that comes with it. Families can proactively seek orders that their children in an appropriate way, especially culturally approved. And it's supported by Indigenous lists, and it's also supported by Aboriginal workers and Aboriginal run services. These cover all different services. This is our first service with myself. We've got Moringa Bio, we've got ALS, and we've also got Legal Aid. And family consultants with the Family Relationship Australia that have Indigenous workers within the list. With the consultants, they're reviewing of the court process and meeting cultural protocols, which is really important. These forms of former court should be really rolled into other courts, including the Children's Court. Along with the amended court process, Indigenous list days allow standard protocols for Aboriginal women's safety. Safety plans can be created and adjusted to meet women's specific needs, including ordering escorts, placement in a safe room, court support, alternative exits, and also escorting to a train station.
Thanks, Tracy. It's great work. And you've been in courts and court support in the work that you've done, the incredible work at Women's Legal Service, and understand how critical these issues are. Can you talk us through the developments, including those implemented under COVID, and how they might be helping to mitigate the safety issues for women and children in the family court?
Sure. I'll talk about that a little bit later, but I'll just talk about generally about domestic violence and family violence in the court and some of the things, some key legislative changes that are required to bring about safety. So as everyone perhaps on this webinar knows, that domestic violence and family violence is the core business of the family court system. Nearly 50% of families in the court are responding or have reported safety concerns for themselves or their children. 85% have reported a history of emotional abuse. More than 50% have reported physical abuse. The extent of family violence in the courts is extensive. 70% of matters involve family violence or child abuse that go to judicial determination. 60% of matters resolved by consent involve family violence or child abuse, and 38% of those cases had 4 or more risk factors. And that's drawn from research from the Australian Institute of Family Studies, and Dr. Ray Caspiev is here, who conducted and led that research. Of interest, I sit on the Domestic Violence and Family Violence Death Review Board in Queensland, and what comes through when we consider deaths, certainly the family law system is part of the deaths that we are considering. In our research, or the data that's presented between 2011 and 2017, so this is intimate partner violence deaths, child custody and access disputes sit in about 19.2% of those matters. So this is at the heart of it, that we cannot segregate issues of high-end domestic violence from the family courts and the family law system. Of interest for culturally and linguistically diverse families, that increases to 35.7. So the courts are present in all custody and access issues are present in 35.7% of matters. Of particular note as well, financial dependence and financial abuse does also come through the caseloads that we've seen as a barrier to women leaving because of the debt issues and women being just held in these relationships, especially in rural and regional Queensland. They can't get out because of this, or they believe they can't get out because of these debt issues. Ultimately, a homicide results, and these are background issues that sit in these cases. So certainly, intimate partner violence, homicide, the homicide of children sits when we're talking about obviously domestic violence. And the Australian Domestic and Family Violence Death Review Network, so all the networks of all the death reviews in Australia, found for the 152 intimate partner homicides considered in their study, 107 child survivors of homicide who had a parent killed or were killed. So it's also when a parent is killed, the children and the impact of that through that family, obviously the lifelong impacts of that. And where children were present and there was a separation, it was also found that the evidence of the perpetrators using those children as a means of controlling or abusing the victim in over 2/3 of the cases. Basically, in relation to getting movement on this matter legislatively and policy-wise, unless domestic violence is centralised, it will be ignored or minimised. If it's just a side issue, if it's all about contact, but as an alternative, please consider domestic violence, it doesn't work. In our experience working in this area over decades, unless legislative and policy reform concerning issues of domestic violence is clearly articulated in legislation, policy and practice and placed at the centre of decision-making, violence will be missed, minimised, ignored by service providers and decision-makers. So that's just the reality of working in this system. The current focus on safety in the Family Law Act is, to an extent, murky. The presumption of equal shared parental responsibility when making parenting orders, it means that that's the starting point unless the court can be convinced otherwise. And Zoe Rathis, an academic at Griffith University, argues, and we agree, this presumption invisibly or unnoticeably invites limited evaluation and encourages acceptance of the notion of equality and sharing. And there is an insidious link in the legislation from the making of an order for equal shared parental responsibility to the consideration of equal time and substantial and significant time. The presumption of equal shared parental responsibility immediately places family violence victims on the back foot in litigation, in mediation, in negotiations, fighting against an assumed norm of cooperative or ongoing parenting. Its links to equal time and substantive time are dangerous. It creates a multitude of opportunities for the perpetrator to exercise control over the victim. So when an order for equal shared parental responsibility is made, it just allows so many opportunities for insidious control to continue and gives power to abusive men who don't assume any responsibility for parenting, but notionally take advantage of the language of equality promoted by the Act to exercise control over the mother and the kids. The presumption prevents children impacted by violence from obtaining therapeutic assistance in Australia. Now let that sink in. That's what it does. Because what it does is it requires the perpetrator to consent when an order for equal shared parental responsibility is made. It requires them to consent to the child getting domestic violence counselling. And do you think that they're going to do that? Of course they're not. And there's also a situation when there's ongoing contact, many times it can be too dangerous. So often the funded services that provide child therapeutic counselling in the domestic violence services is actually too dangerous for them to provide actual therapeutic help for children. They actually have to provide it to the mother to be able to try to help her to be able to help her children. It also stops victims. The presumption stops victims from moving states, geographical zones, or even suburbs for safety reasons. It holds victims in the same location as the perpetrator, which is highly dangerous. And I would like some consideration to be given to that in the recent murders that have taken place. And any of these murders, was she able to move away? Because often she's not. And if she'd ever got advice, she would be told, you're taking a risk in moving away. The court will bring you back. So this is what this presumption does. It also has an impact on legal aid and the legal aid funding in the sense that it emphasises, the emphasis on shared parenting means that funding goes in that way. So if you're sort of going against that, it's quite difficult. I'm not sure how much longer have I got?
A little bit of time.
How much?
You have about 3 more minutes.
Okay. Shared care incentivises abusive men to litigate. So perpetrators have a mindset of entitlement and they pursue their rights to shared care, sometimes in unrelenting ways. The presumption of equal shared parental responsibility and emphasis on shared care incentivises litigation. So at the same time as the government is funding a cross-examination scheme, and hopefully will continue to fund that important scheme to ban direct cross-examination, it has a system that incentivises litigation. And so that is never going to stop. So that it has economic impacts. The shared care emphasis has economic impacts because it speaks to them. They hear it, they know it, and they pursue it. Victims of violence are hyper alert and attuned to their kids' survival and their survival, and they're reading the perpetrator's mind. And if they believe he will be appeased by shared care, they may give in as a survival tactic, or making a risk assessment that things could get worse if they don't, by attempting to avoid litigation or litigation abuse. So the system itself is very attractive to violent men. The court system is a very attractive, so they're attracted to it. They're coming to it because it is disjointed, under-resourced, and if it's a system that's not attuned to perpetrator tactics, it's even equally more sort of attractive. And what we know from the Law and Justice Foundation in their research into domestic violence, it found that the legal needs of domestic violence victims was enormous. And we can sort of presume why that is the case, because not only are they pursuing litigation for safety, but they're kind of reacting also to this kind of incentivised litigation that's being taken place against them. I mean, we don't agree with the recommendations by the Australian Law Reform Commission, and the government is not removing that presumption. We think they're tinkering at the edges, basically. It actually isn't going to make that much change. Changing a few sort of words around is not going to change this. That's not going to change this system. We need to really rethink everything. What we actually need is a domestic violence and family court system, because principally that's the families that are going into this court system. Up to 85% of matters involve domestic violence. That's a domestic violence court. And so we have to change our mindset and make it much more risk and safety focused.
Janet, in light of the rather compelling stats that Ange has just given us around violence in the family court and in family court matters, can you speak more to the current focus on safety in the court?
Sure. I think, just reflecting on what Angela said, I think there is certainly a real appetite in the court at the moment to both improve our knowledge and understanding of family violence, and also the mechanisms by which it can be identified and managed within the constraints that the court has to work within. I think you're keen for me to talk particularly about the Safe and Together model and that training that's now being rolled out in the court. Many of you may be aware of the Safe and Together model. It's been around about 16 years, developed by David Mandel in the States, and it's been rolled out across child protection jurisdictions in many parts of the world, including Australia. It's a child-centred model, but it assists systems to identify coercive controlling violence and other types of violence and improve the system's response. It is child-centred, as I said, in so much as it challenges us to think beyond the limited understandings of children being exposed to, by that I mean witnessing family violence, and asks us to think more broadly about the impacts of family violence on children and the multiple ways and they can be impacted beyond just witnessing. There I'm talking about things like the impact it has on parenting behaviour, both of the victims and the perpetrators, and also on the impact it has on the broader family ecology. So we're talking here about things like the housing, financial stability, access to schooling and stability of schooling, all of which we know are really important for kids' well-being, but also can be impacted by family violence. I think it's too simplistic for us to think about family violence as purely a relational issue between the adults. We need to think more broadly, and we need to conceptualise family violence as a parenting behaviour, a parenting choice. And in so doing, we need to hold both mothers and fathers to the same standards. The court is sometimes criticised for having a sort of contact at all costs approach, and I think that's probably a somewhat simplistic critique, and the arguments of the men's groups would be evidence of that, because they would argue that the approach of the court is exactly the opposite to that. So I think that sort of underlines the complexity of the space that the court works in. But that's not to say, however, that I think there's still a lot of room for improvement in the courts in our understanding of family violence, and I'm really hopeful that the Safe and Together training that's being rolled out will go some way to doing that. We work in an environment where there is very often mutual allegations of violence, and the Safe and Together model will help us to really identify the patterns of violence, which allows us to then identify and establish who the primary perpetrator is. I think the other thing that really I like about the model is it helps us see victims' behaviours as recognise the protective nature of them sometimes, that I think we can miss. And I think that's a really important thing, that we actually look at the victim's behaviours through that protective lens. And likewise, I think we need to be focusing in on perpetrators and holding them to account to the behaviours and the impact that they're having with children. So I'm really excited about the Safe and Together model being rolled out in our courts. I've been very fortunate to be sort of very actively involved. I've been working with David Mandel for many months now, and he's quite excited too. This is the first time in the world that the model has been applied so formally and comprehensively in a family law jurisdiction. So it's a really exciting time. It's being rolled out to family consultants, who are the social scientists in the court, to registrars and to judges. And each arm of that the court will get a slightly different package of training dependent upon their role. So that's a really exciting initiative, and I know it's been received quite well in the broader sector. And I think we hope to see some real evidence of change coming through as a result of that program.
Well, it's definitely had an impact in the child protection arena. So if anything, in terms of looking at the behaviour of the perpetrator as a parenting choice, there could be some impacts in terms of that shared presumption going forward.
It'd be good if it was removed, but we don't.
The other thing I wanted to take the opportunity to speak about, and I didn't speak about before, was the Lighthouse Project. And I think you asked me to give a bit of an update. Now, many people might know about this. This was an initiative of courts that government agreed to fund. It's been rolled out in 3 locations. It's a really exciting initiative. It's currently active in Brisbane, Parramatta and Adelaide. And I think it's going to go a long way to addressing some of the things you raised, Angela, in terms of getting in early and identifying the risks and having those inform the case management pathway from the get-go. So this, the Lighthouse model involves litigants being invited to complete an online screening tool called the Family Doors Triage tool. It's a confidential tool, but the responses are then reviewed by a specialised team. If matters are identified as high risk, then the parties are offered an interview with, it's a family consultant, but they're acting in a role as a family counsellor because it's confidential. And then if it's deemed to be appropriate, the matter's then put on a new dedicated list called the EVIT list, which is a specialised list for those high-risk matters. And in the course of that list, there's a number of sort of requirements that put some parameters around the way the case is managed to assist us getting in all the relevant information really early on, so that much of that information, assisted by the co-location workers, is available for that first hearing. And those hearings are undertaken by senior registrars, and there's quite a tight time frame for things to move through to conclusion in the EVIT list. So that's a really exciting development. Feedback at this point is really positive. There's a a formative review being conducted by an external body at the 6-month mark, and then there'll be a final review when the pilot comes to an end in June 2022.
Okay.
So we've got just another year. And then, look, I think we're all hoping that if the outcome of the review is good, that government might consider rolling this out more broadly. But I think it's going to go a long way to addressing some of the many issues that have been raised here by the panel today. So I don't know if I've got a time to give you a quick...
You've got 2 minutes.
Okay, I thought a good way to... okay, I'll be really quick. Give an example of a matter that's come in through the Lighthouse Project, and perhaps think about how it might have been managed if it wasn't on that path. So this was a party whose child had not been returned, hadn't seen the child for 5 weeks, so lodged an application for interim and final orders, was in a licensed location, so was sent the screen, completed the screen within 48 hours, had an interview with a family counsellor within a further 48 hours. It was placed on the EVIT list within 6 days of that, and had an interim event shortly after that. I think it was about 14 days that the interim event conducted by a senior registrar who had a lot of information from other agencies who were already involved, and the child was returned to the parent at that interim event. And the party was also connected with a range of support systems and services, including the FAS in the court. So, that was a case that in the normal pathway would probably have been listed for a mention in 3 weeks' time. So that's a really good example of how that pathway, because that person chose to do the screen, and we're encouraging everyone who's in those locations to do the screen, then was enabled that case to be put on that dedicated pathway that saw actions taken quite quickly.
And just picking up on something that Jane was saying, how do people know about it if people didn't know about the services that were offered by the court? In your research, Jane, how is this being?
Well, that's one of the roles of the family counsellor, particularly to provide referrals and to look at what can be done within the court. I think the court probably has not been proactive enough in the past about safety planning. So and that's also related to the notice of risk. Now, if we get all that information, if we're proactive in the beginning, and Lighthouse is certainly a very proactive approach, the safety plan is actually made at that family counsellor interview. So I think, it's a really exciting project, and an ambitious one, but I think I think the rewards will be great. So
Thank you. Yep. Thank you, and I think we'll look forward to those the evaluation outcomes next June. So looking forward, Ray, I'd like to bring you into the conversation. Can you talk to us about what you're hoping to find with the current research that you're doing as part of an ANROS project and how it might help inform improvements for safety for children?
Oh, thank you, Michelle. The ANROS funded compliance with an enforcement of family law parenting orders project allows us to further examine 3 themes from our previous work that we've already heard about to some extent today. That are relevant to safety in the family court. The first theme, of course, is family violence and safety. As you've already heard from Angela today, our research, the evaluation of the 2012 Family Violence Amendment Project, really did demonstrate very strongly that the core user group of the family court are families affected by family violence and other risk issues, such as mental ill health and substance abuse. One of the things that we're looking at in the compliance with parenting orders project is the extent to which such concerns are associated with a lack of compliance with parenting orders. One of the grounds on which a reasonable excuse for non-compliance can be upheld is in relation to such concerns. So we'll be looking very carefully in our project at the dynamics associated with a lack of compliance and conversely compliance with parenting orders. The second somewhat related theme that I do want to highlight particularly now, because it hasn't come up to a great extent in the discussion thus far, concerns the participation of children and young people in family law proceedings. We know from our 2014 study on independent children's lawyers And our 2017 study, which was led by my colleague Dr. Rachel Carson, on the experiences of children and young people in the family law system, that children and young people are not always heard to a sufficient extent. Concerns about their safety are one of the areas particularly highlighted in these studies as not being given sufficient attention. One of the experiences that has stayed with me over time from our research comes from interviews with 10 children and young people from the Independent Children's Lawyer Study. This young person explained to us his experience of trying to leave an unsafe carer for safe carers. This young person explained to us his experience of an ICL, a protracted court process, an ICL who, from his perspective, did not pay sufficient attention to his lack of safety. After many, many months of engagement with the court and the ICL, ultimately the circuit breaker in that young person's experience was a crisis in his unsafe care situation that caused him to call the police and have himself removed to a safe care situation. In the Compliance with Parenting Orders study, we'll be looking at the extent to which children and young people are themselves drivers of non-compliance with parenting orders, and to the extent possible how this has arisen. Certainly one of the international studies by Liz Trinder and colleagues highlights how a significant reason for non-compliance in the UK was children and young people saying, no, I'm not going to go along with this arrangement anymore. So that's one of the issues we'll be looking at in our study. The third theme concerns systems abuse, which we've already heard about to a significant extent today. Several of our projects, including particularly the ANROS-funded Domestic and Family Violence and Parenting project, have shown how abuse of systems and processes, including but not limited to family law systems and processes, can be part of an ongoing family violence dynamic. The Compliance with Parenting Orders project will look at the extent to which such a pattern is evident in parenting order enforcement proceedings. The design of the project deliberately casts a wide net to assess not just the operation of the enforcement regime under Division 13A of the Family Law Act, but compliance with parenting orders generally, not just among parents who are involved in enforcement proceedings. I should emphasise, as well as investigating non-compliance, we're very keen to understand the factors that support compliance, both personal and systemic, because of course in understanding compliance you get a much better idea about what it is in the families where there's non-compliance that drives the non-compliance. So the methodology is based on 4 key primary data collections. We currently have an online survey of professionals in the field. So if anyone listening works with separated parents has not yet completed the survey, please consider doing so. That survey assesses the issues and dynamics of compliance and non-compliance with parenting orders from the perspective of professionals who work in the system, including the courts. We're also conducting interviews with judicial officers, and Professor Helen Rhodes from the University of Melbourne is a consultant on this project, and she's currently conducting these interviews, which is still ongoing. So we're very interested to find out how the system looks from the perspective of the decision makers. Another element of the study involves seeking the views and experiences of separated parents with parenting orders from the courts through an online survey. We're asking parents with orders made during the last 5 years by consent or judicial determination, or consent after a litigation process has been instigated to complete the survey. We want to hear from as many parents as possible, whether or not there have been issues with compliance. So we want to hear from parents who are complying or have limited issues with compliance, as well as the parents for whom compliance is an issue, as well as parents, of course, who are involved in enforcement proceedings, but we do know that that's a minority of all parents with parenting orders. That survey will be in the field early next month, so we are hoping for a very good response from separated parents with parenting orders to understand these important issues. Another element of the study is based on data collection from court files involving parenting order enforcement matters. So we're looking in that component specifically at how the legislative regime in Division 13A operates. We currently have teams of data collectors in Melbourne, Sydney and Brisbane collecting data from around 1,000 court files to examine how enforcement applications are dealt with in the courts. For all of these elements of the study, we've had fantastic support from the Family Court of Australia and the Federal Circuit Court of Australia, as well as stakeholders such as Family Relationship Services Australia and the family law practitioner groups. This is a complex and important study, so working with those organisations has been invaluable. And it's quite clear from the level of support that we've had from these stakeholders that there's a genuine recognition of how important it is to understand what's going on in this area and how parents can be supported to comply with court orders, and court orders in turn can be made compliable with, as it were, to sort of murder the language. So look, I'll finish on that note. Thanks, Michelle, for the opportunity to talk about that project. And you can see from the discussion today how important these issues are.
That will be a critical evidence base going forward in terms of both practice and legislative reform. And Ray, I can just point out to the audience that the survey for practitioners has been run through Notepad.
Yes.
It still will be in next Thursday's edition if you have missed out. Okay, well, thank you for the discussion so far. As we near the closing date for the submissions to the review of the ban on direct cross-examination under the Family Law Act, I'd be really interested in some comments from the panel on what you hope to hear from the review, what you hope for from this review. Jane, I thought I'd ask you to begin, given that you did the research.
Well, obviously direct cross-examination was one of the key concerns around self-represented litigants, although not the only concern. We were quite lucky as a research team that the ban was put in place and started operating whilst we were still in the field. So even though our project wasn't designed to evaluate it, we did get to see the early implementation period. There were some things that I think were just implementation administration issues that I hope are addressed. Although I must say the research team still gets contacted on occasion by women who don't know what to do, whether it's a mandatory or a discretionary order or so on. So there obviously is still some information gaps in terms of how the scheme operates. In terms of the review, I think there's a number of areas that need to be looked at. And so one is the way in which the discretionary orders operate. So only a small number are going to fit the mandatory scope where there's a conviction or a charge or a current protection order. So what is the guidelines for judges? And we see some variation about whether they're looking at there was a previous AVO. There's been some suggestions in the case law that they've looked at the availability of funding and so on. There's also a question about whether self-represented litigants know that they can ask for a discretionary order and how they would go about doing that. There's no means test for eligibility of the scheme. And so one of the things that did emerge in our study was the potential for misuse of the scheme by alleged perpetrators, so becoming unrepresented quite close to the hearing date. This necessarily means that the hearing date will be adjourned with all the repercussions that go for the other side. And so there perhaps needs to be some tightening up in that area. But overall, the scheme is seen as incredibly valuable and important.
Thank you. And Ray, did you have a comment that you wanted to make about the...
Well, look, like Jane, I'm very interested to find out what the review concludes about the operation of the discretionary aspects of the regime. But also I'm very interested to understand from the review how often the orders, whether mandatory or discretionary, would be made in property matters, because we often think of children's matters in this context, but I think this is an equally salient issue in property proceedings.
And Ange, what are your feelings?
It's extremely important piece of legislation. Women's Legal Services drove that legislation right from the beginning. It's close to our hearts, it's close to our clients. It has such a deep impact on women when they've been cross-examined by their perpetrator. So to put those, and we have to remember that, and so to put those protections in place is really important. I think the discretionary nature has been raised by Women's Legal Services as an issue, and of course I just reiterate, I suppose the bird's eye view back from the kind of in the weeds of how it works is that we have a system that incentivises litigation, and that we have this system, and everyone's scratching their heads down in Canberra going, why are we spending so much on this system? Isn't this strange? Well, look at your system. You incentivise through your legislation and through this system violent men to litigate. If you fix that up, the economics are going to fix this up as well. So that's my message to the Attorney General's Department. I think there might be some people on here today. That's my big message in relation to that scheme. Incredibly valuable, but that's just going to continue to increase unless you fix this other end.
And Tracy, from a local court perspective, what would you hope to see?
I would hope for the scheme to come into the local courts, because I've been in a hearing before and I've seen my client get questioned by the defendant, and it wasn't about the matter. It was for his own personal questions. And then for her to come off the stand, come into the safe room and disclose more abuse that she hadn't actually reported, because she'd been completely re-traumatised all over again.
Okay, well, let's move to our questions and answers. We've got about 20 minutes or so, and we have many questions. We'll try and get to as many as we can. The first question from the audience, and this is for you and Janet and Angela. How do you think safety of women experiencing domestic and family violence will be affected by the courts merger? Janet.
Okay, thanks. Look, I think a lot of people don't understand how complex the system is at the moment. And as Jane's research highlights, if you're not represented, it's so challenging to find your way through, know what's available to you, and understand the system. So I think perhaps people aren't always aware that there are the two different courts in which a family law matter can be heard, there have been for over 20 years now, since the Federal Magistrates Court was introduced in 2000. And that court has grown significantly over time. And now, roughly 90% of family law matters get heard in the Federal Circuit Court. So I think there have been some concerns about the loss of a specialist court. But when you think about the fact that 90% of cases are already heard in the Federal Circuit Court, I think it helps to really focus the mind on the fact that the Federal Circuit Court has become a specialist court just by the nature of the matters that it's hearing. But having this two-court system that people can enter, having two courts with different rules, different processes, is really quite challenging. So I think the creation of this sort of single framework for the family law courts is going to make the system a lot simpler. The two courts are going to be maintained, but just at two different divisions. But there'll be a number of practical changes that will simplify the system. So, for instance, at the moment people can lodge in either court, but going forward they'll only be able to lodge in the Federal Circuit Court. So there'll be a single point of entry into the court, and that will be supported by legislation. The rules in each division will be the same, so we've moved towards a harmonised set of rules. There'll be greater opportunities for facilitated ADR within the court process in this in going forward. And I think it's important to say a lot of these were initiatives that the reforms that the court was driving anyway, but they're going to be facilitated by this by the bringing together of the two courts. I think you will see in the new environment, we'll see a simpler case management pathway where there's less court events. Sometimes people go through so many different events and over such an extended period of time, and that will help reduce the opportunities for systems abuse. And also I think we'll see, I'm very confident we'll see less delays, and so people will be getting speedier but appropriate resolution. So I think that there's a lot of benefits that are going to come with those reforms, which are supported by this effective, what's called the merger, and it's just bringing the two courts together into this sort of administrative framework.
And Ange, what are your thoughts on?
Our thoughts are that with the family law community, so we supported a merger, but we just supported a merger the other way. So we supported a merger into a standalone specialist family court. We never supported 21 years ago the establishment of a separate court. It was just a ridiculous decision. It's had an enormous economic impact on Australian society to have this two-court system, creating more complexity in a more already complex system. And we were against that at the time. And obviously it happened 21 years later. We think, I actually think it's a cost to our Australian society to lose a standalone family court. I think it, in other societies that don't have a standalone family court, they are now fighting for that because there's some, I think it lowers the status of the court to be sort of in this sort of merged arena. I think that there's greater probability in a standalone specialist court of having the appropriate judicial appointments, because I think it's more obvious if you're appointing someone who just doesn't have that level of knowledge to a standalone specialist court. It's just a bit more noticeable. I think that it also future-proofs the court to have a standalone family court. It's much more difficult, although it is possible. We've just seen to obviously, remove our family court. It's much easier to remove a list. It's quite easy to remove a specialist list. Those decisions can be made in the future. So that's our reasons. Obviously, we've lost those arguments and we move on to the next arguments. There's more arguments to be had. Don't worry.
No doubt. Janet, you mentioned systems abuse. One of the questions from the audience is in your view, what more should be done to respond to systems abuse? And you've outlined that perhaps under the merger there is an opportunity to respond to systems abuse. I'd be interested in your views, Ray. And you've done a little bit of research on this, but should we be doing more to respond to systems abuse?
Well, Michelle, I think it's a really good question, and our Domestic and Family Violence and Parenting project actually demonstrated that there's a whole range of systems and processes that can be brought into play to perpetrate abuse. We interviewed women whose partners were not only using the family law system, but also systems such as the child support program, child protection systems, social security systems. And, one of the significant issues that needs to be considered in this context is if you think about one of the mechanisms that's available to courts to address systems abuse are its unmeritorious or vexatious litigation powers. However, those powers only apply to the proceedings in that court. So having this broader kind of span to address and to consider systems abuse in all the different ways that it occurs is really important. So that's one point that I'd say is a challenge for making policy in this area. And whilst it is a challenge, it does need to be grappled with.
And Molly and Jane, your research both touch on this. We'll start with,
So certainly just from what Ray was saying, I recall one woman we interviewed who indeed was bringing vexatious litigant proceedings against her former partner in the state court system. And indeed many of the women we interviewed were representing themselves across multiple systems. And so she will only get a response in that system if she's successful. I guess one of the other things that I think whenever we think about reform and measures in this area, we always have to be careful about unintended consequences. And indeed, just thinking about some of the women who continued to litigate to ensure safety, sometimes some of the measures that we might put in place can be blunt, that are there to address systems abuse, but might actually also, unfortunately, stop legitimate claims. And so we just need to be careful in assessing how we might go about addressing systems abuse. The woman actually who did the vexatious litigant matter in the state courts, she had also been subject to 3 contravention proceedings in the family law court, all of which were found to be unsuccessful. She just wanted it named. She wanted the third one, not just chucked out, but named as systems abuse, and that would have made a difference to her.
Molly, did you?
I think that when we're talking about systems abuse, there's just that dynamic where abusers will use any tool that they have at their disposal to do abuse. So naturally, they'll use the family law system, they use child protection, as Ray pointed out. There's all kinds of systems they can use. And this gets to this issue of abusers manipulating the image that they have, manipulating the image of the family. And this is something that comes up on the death review board all the time. It comes up when I'm training police and corrections officers. And I think one of the answers to dealing with systems abuse is just making sure that the whole range of professionals, whether it's psychologists or social workers, lawyers, judges, mediators, anyone that's involved in that process actually has some in-depth domestic violence education, because these dynamics we've known about since the 1970s. There's no new discovery. We're calling it coercive control now, but all those dynamics about using the children and manipulating your public image have been on the power and control wheel since like the 1980s. So I think just education about domestic violence, not just for the courts. I don't think it's fair to put it just on the judicial officers. We certainly need it in legal education, in criminology departments, psychology departments, and social work.
Yeah, great. Thank you. And we haven't talked much about mediation today, but I'm going to, another question from the audience is, can mediation work or fix anything in this context? Angela, I know it's a topic close to your experience and heart.
I think that it can be an option, definitely, but with more specialist assistance and resourcing. I think that as part of Women's Legal Services Australia 5-step plan, there's always been that extra layer of specialist mediation or domestic violence mediation that can take place or should take place, we would advocate, in the community, that could provide that real specialist intervention. And it also would act as a bit of a triage as well, because if parties are going through a very sort of specialist framework where safety is absolutely paramount and they are unable to really go through that system, it really is then you need to go to court, here's your ticket and go to court. And it acts as an extra layer of protection in some ways in the system of matters that, with some specialist assistance and intervention, may be able to resolve themselves without going to court. And it actually is resource intensive. I think it requires men's workers, women's workers, lawyers, specially trained mediators. But gee whiz, it's actually a lot more cost effective than ending up in the court system. So we have to be better at providing triage and diversion, specialist diversion programs outside of the court, so that we ensure that those matters that do get to court are absolutely the matters that require the court intervention and assistance. So definitely, I think that it's possible, but it requires, you know, and there's lots of models out there. They just need resourcing.
Ray, did you have?
Look, I think what Angela says has a lot of merit in it. I think if you look at the structure of the system at the moment, we say to the people who are complex and difficult and have family violence and safety issues, you know, we challenge, we channel them into a court litigation pathway that's expensive and adversarial. And really, so they're being treated differently to the people that don't have those complexities. So I think there is a gap in the system because we do want people, and certainly there always will be cases that aren't suitable for mediation, but there is highly likely to be a spectrum of cases where that kind of process, carefully done and well-resourced, could well be a significant benefit to the family, potentially, particularly the children, if it's cost-effective and non-adversarial. You know, in our research, it is always the FDR processes that attract the highest satisfaction ratings from parents, even parents with family violence and safety concerns. So I do think that that's an area where there needs to be further development in the system. And I am encouraged to hear about what the court's doing in that respect. So yeah, there should be some more options for those people in that situation.
Janet, did you want to close on this comment?
No, look, well, just I did talk earlier about the introduction of ADR back into the court for parenting matters, and I think I totally agree that as much that can be done before people darken our doorstep, I think is a great thing, and I think you'll find everyone in the court supports that. And part of our early triaging, particularly through the Lighthouse, is to identify those parties that actually should go back out, and we're currently negotiating the processes for that with the FDR providers in those Lighthouse locations. So, you know, it's not that we want everybody to come in, but I think it is important that people get these multiple opportunities, because at different points in time there might be a different capacity or readiness to undertake dispute resolution and to offer it in a different way. And I think there is much around what you're saying around doing it in a very supported way, and I think that's what the court is able to offer now right at the beginning. So you're not too far. Yes, you've crossed the threshold, but you're not too far into the process where we're going to offer you this opportunity with the support of your legal reps and really well-informed and trained registrars and family consultants and independent children's lawyers. That's a really exciting initiative. And my staff, I lead all the family consultants who are going to be and have been very active working with the registrars, and it's proving to be very rewarding work for them. It's made the role much more interesting. That's a bit of a sell for anyone out there that's interested. We're recruiting. Second recruitment today. I've got a mission.
We'll send the link.
But it is a really, really exciting development. Family,
it is.
people in my area
Absolutely.
used to do this work, and it's made the role much more varied. And I think there's but they bring all their family violence expertise, and there are many matters where between the family consultant and the registrar, they will determine this isn't appropriate for dispute resolution. And I'm also aware of some matters where the outcome has been really favourable for the victim, because having being in a process facilitated within the authority of the court actually can be a bit of a wake-up call for some perpetrators. So I think, you know, I used to run an FRC, you know, FDR all the way, and I'm excited that that's now being brought into the court, not as an alternative, but just as another opportunity when it is appropriate.
Tracy, anything from the Court Advocacy Service on mediation, or what happened? Do you get requests for this as well, or?
I do
And how do you
at
respond?
times
Yeah.
request it, and I do go in and I am a support person there. I think it's really important to make sure the cultural protocol is in, there's a complete wraparound services,
Yeah.
and that obviously the safety is put in place and is proper too. Yeah. But I do think it's a good idea.
Great.
Yeah.
We are coming toward the end, so I think what I'm going to do is there's 2 questions left that I'd like to put to the panel, and maybe the first one to Angela and Janet, and maybe Jane if you're interested, or anyone else. But what are some practical ways to prepare clients for the family court process? Just, 3 practical ways each.
I think it's really important that people understand the court is a very different institution to that many of my colleagues here and the people attending today work in. And its function is to apply the law to the evidence put before it. So we come back to the critical importance of the evidence, and that's been a point that Jane's made particularly. And so, I also think it's important to acknowledge that applying the law to a family system, which we know by its nature is messy, it's dynamic, it's really complex. And so that's a really tough job that our judges have. So I think, anything that's going to improve the evidence before the court has got to be helpful for your client. So if it's a Lighthouse location, encourage them to screen, encourage them to provide really fulsome information on their notice of risk, a really comprehensive briefing to their legal rep if they have one. Proactively bring things to the court's attention if you're concerned about attending the court. Let the court know. You can contact the court through the National Call Centre, and you can have plans put in place. Make sure the court knows about any other agency that's involved. If the child protection system is involved, if there are other systems involved, make sure that's put before the court. And if any professionals working with the individual parties are able to assist by providing some evidence for the court by way of professional reports, that can be really helpful, because when you're dealing with a matter where there are really two opposing and contested accounts of what's gone on in a family, to have evidence prepared by a professional, even if it's a professional working with one party, does really inform the court well. Yeah. So there'd be the things I'd be encouraging you to assist your clients and encourage them to do.
I think that's really helpful. Jane, did you have one?
I'd just say that information is invaluable,
Yeah.
whether they're represented or not. Having some knowledge about how the system works, what to expect, actually just breaks down some of the barriers. For self-represented litigants, there's also a need for centralised authoritative information. Certainly the people we spoke to accessed a range of sources, some of which were more reliable than others.
Yeah, great. And Molly, I'm just going to quickly go around. Did you have anything?
I don't have anything to add on that one.
I just, like you were just saying, it needs to be broken down. The client needs to understand what they're facing, and obviously the supports really need to be put into place, and proper cultural supports and safety things as well.
Around that, yeah.
Really get advice where at all possible from a women's legal service who is specialised in relation to domestic violence and family law, and get advice as early as you can, even if it's before separation, and if it's safe to do so, get yourself legal advice as well as domestic violence safety planning advice, so that you can set yourself up as much as possible. And Women's Legal Services, out of the budget, just received, similar to the court, well, I'm sure it's a very different sum of money, but also received an increase in funding, which is very exciting for our organisation, and means that for our organisations across the nation, which means we can assist more women and Aboriginal women's legal services as well. So,
Excellent.
I'll leave it.
Okay, well, Ray, you can start on our last. This is a great question. Someone has written in and said, are we getting anywhere? Ray, you can start, and I'll whip back around the panel. Are we getting anywhere?
We are getting somewhere. I think there's no doubt about that. It's been very encouraging to hear about the initiatives going on in the court, particularly the Lighthouse Project. I think we all recognise that there's an enormous amount of work to do. Nothing happens overnight. but there are so many positive initiatives, pilots, developments that I think, we do take a sense that things are shifting and it might take a while, but every step is an important one.
Thanks, Ray.
I think that we are. I think that the positive initiatives of the court are amazing and really do give so much hope to many people that work in this system. And as you say, the different pilots that are going on, et cetera, et cetera. I think that it really has to be supported by legislative change. But can I say it again? I'm going to. Yeah, and a real focus on safety and risk. And it's important because it's not just all about the court. Most of a lot of our clients come to us already having entered into 50-50 arrangements. And the recommendations by the government of tinkering around at the edges of putting another exemption here and exemption there, that's not going to change. So we need substantive change in the legislation to move that mindset towards safety and really support mothers in domestic violence situations to be able to know they've got that the system's going to back them up. He's going to back their safety decisions up because we don't have that confidence at the moment.
Tracy, are we getting anywhere?
I think we are slowly. We still have a far way to go. And I really think we need more Indigenous list days in other family courts, absolutely. And like I said before, that needs to come and trickle down into like the children's court as well.
Thank you. Molly?
I totally agree with you. We're getting somewhere, but there's still a long way to go. I know that when I speak to legal professionals, there are a lot of attitudes that are really closely aligned to some of the attitudes and beliefs that abusers hold. So if we actually want to decrease domestic violence and address the systems that aren't responding as effectively as possible, we need to make sure that we're thinking and talking more like the survivors that are able to protect themselves and their children and less like the abusers.
Yeah, thank you. Jane?
I will say ditto for everybody. And it is really exciting to hear what the court is doing at the moment. I guess one of my concerns is just around that we've had lots of pilots before, and it is about asking the government to commit to continuing those programs if the evaluations prove to be effective, and it costs money.
Yeah. Thank you. And Janet?
Well, I'm heartened that other
anywhere?
people see that we're getting somewhere. I've been in the courts for just under 5 years, and I think we've made enormous strides, particularly in the last couple of years under our new leadership. I've seen really significant change and, in my view, all for the better. I think we are working much more with external agencies than we have in the past. And I think, as I said before, I'm really excited, and the injection of funds into our system, which has not had significant funds for a very long time, I think is going to go a long way. So I agree with everyone. We're definitely getting somewhere, but no, we're not there. I think this is going to be an ongoing venture for many years to come, but I think the gains are very significant. And I think I want to pay sort of credit to my colleagues at the table. I think it's through us all working together and the issues that they continue to raise and bring to governments and the court's attention is certainly critical in the progress that's been made.
Yeah, and I'd like to thank you all. It's been an incredibly insightful and I think also a very useful conversation. I'd also like to thank the audience for your questions. I think they've also generated a lot of discussion amongst the panel, and and they're difficult conversations. But I think together and so respectfully, you've all been able to have your say, and that's to the benefit of all of us. So we've come to the end. We're a little bit over as well. I did want to just remind the audience that the call for submissions to the review of the ban on direct cross-examination under the Family Law Act closes on Friday, the 28th of May. So be sure to, if you'd like to have a say, to get those submissions in. The webinar will be recorded if you haven't been able to stay for the extra 4 minutes. And it'll be available on the ANRO's website. You can also you'll be able to download the resources from that we've been talking about today, and potentially the jobs that Janet's been referring to. We could come work with us included. And as you exit the webinar, there's a short feedback survey, and we'd really appreciate any comments or feedback that you might have. Thank you again to this wonderful panel. I really appreciate the time and energy, and especially the trip to Sydney that you've made to present with us today and to be here with us today. Well, I'm Michelle Robinson on behalf of Anne Rose. Thank you very much and goodbye.